Good morning. Just kidding. Good evening, beautiful humans. Today is December 15th, 2025. And tonight we are diving back into one of the most talked about cases in the country right now, Aaron Spencer. And he is the Arkansas father who is charged with second-degree murder for killing the man who is allegedly S.A'ing his 14-year-old daughter. Here's the background if you're not familiar with the case. Aaron Spencer, now 37, lives on a farm near Cabot, a little town called Cabot in Lonoke County, Arkansas, with his wife Heather and their two kids. Back in July of 2024, 67-year-old Michael Fosler was arrested on 43 counts, including S.A'ing of a minor and internet stalking of a child, all involving Spencer's then 13-year-old daughter. Despite those charges, Fosler was released on bond, $5,000 bond, as a matter of fact, and was awaiting trial. Then fast forward a few months, on October 8th, 2024, just after 1 a.m., Aaron Spencer is woken up by his daughter's chihuahua barking. Goes to check her room. She's gone. Tells his wife, Heather, to call 911 to report her missing, and Spencer immediately goes out to look for her. After a short while, he actually spots Fosler's white F-150 on Highway 236 with, of course, his daughter inside. What happens next is where the case gets legally complex. Spencer pursues the truck for approximately 6 miles. He's honking, he's flashing his lights, he's trying to get Fosler to stop. When Fosler doesn't pull over, Spencer rams his truck into the back of the F-150, sending it into a ditch. Kind of a pit move. Spencer then fires 16 rounds, 15 of which strike Fosler. After Fosler had gotten out of the truck, after Aaron Spencer had been yelling for his daughter to get out of the truck, and she wouldn't, for whatever reasons. The 15 shots put Fosler down. Aaron then climbs on top of him, pistol whips him in the face, calls 911 to tell dispatch Michael Fosler is dead on the side of the road for trying to kidnap my daughter. I had no choice. Subsequently, Spencer is arrested and charged, originally with first-degree murder, later reduced second degree. He's currently out on $150,000 bond and has pled not guilty. And his trial is imminent. It's set for January 26th, 2026. Oh, and he's also running for the sheriff of Lonoke County. So the question we're going to break down tonight is, what are all the new motions that have been filed as of the deadline? We're going to get into them. We're going to talk about them. We try to consolidate, making it where we're not reading a motion or a reply and then reading the brief, because the brief always contains almost the entirety of the body of the motion itself. So Allie was real big on not being duplicative. So we've cut that in half. So hopefully it'll be nice and fluid. And speaking of which, I, as always, am joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all.
Hey, what's up? Oh, and I forgot, I'm Bob Mata, your host. Welcome back. Happy Monday. Happy Monday. We're going to dig right in. It's been a minute. I think the last Spencer live that we did, I think you said was what, November 26th or something like that, right?
Correct. And before you dive in, I just want to say some of the things we're not reading deal with. Voir dire, the state filed a response to the defendant's motion. They were asking for individualized voir dire, if not that small group voir dire, meaning jury selection, instead of having the whole panel be polluted by what somebody might say. Do it individualized, or at least do it in small groups. The state's response was, we agree it needs to be in small groups, but individualized is a little much. And then the judge set an order where she seems to not address, or she didn't address, whether it's going to be a small group or not, but she did ask the parties to submit specific questions that they want asked. So that's where we stand on that. And then there's a couple of motions that have um, the state's response to the defendant's original motion, and then the defendant's reply. So I think we should start with those. I don't know. What do you think?
So what do you want me to start with? So do you want me to start with the defendant's brief?
No, because it's the defendant's response brief that's replying to the state's response.
Okay, so
for example, you can do the one concerning cell phone data or spoliation of evidence from the state.
okay.
It's the second and the fourth from the top.
Okay, so I'll start with the state's brief in support of. All right, let's see. Let me pull it up here. Get it rolling.
Meanwhile, let's say hi to History and Homicide, member for 9 months. Thanks for your continued support. Love my DD family. Thanks for having me. And the Goodmans, member for 6 months. Thanks for your continued support. Hey, Bob and Allie, love that you're covering this. All right. So again, this is the state's brief in support of the state's response. So the defendant filed a motion to exclude evidence concerning the cell phone tower data. And now this is the state's response. And after we read this, we're going to read the defendant's reply to this very response.
Got that? All right. So comes now the state by and through Deputy Prosecuting Attorney Christine Hendrickson, and in support of the brief, and its brief in support of the state's response to the defendant's motion to exclude evidence concerning cell phone tower data, states the defense, and this is the intro, the defense alleges that cell phone location data is inaccurate and should be excluded from evidence. However, the use of historical cell site analysis has now been deemed firmly established and reliable by numerous courts across the country. Into the argument, the state previously filed a notice of expert testimony and listed Special Agent Blake Downing with the FBI as an expert on cell phone tower location data. Special Agent Downing has been previously testified, and the bin shouldn't be there. A little typo there.
Has been previously. Has here been done. He done did that before.
He done up and did it. Has been previously testified in this court and certified as an expert and permitted to testify regarding cell phone data location data rather. In addition, he has been certified in other Arkansas counties and testified 7 times in Arkansas cases. McCollum v. State, and that's we don't get the year on that. So Special Downing has testified in over 25 cases across the nation as an FBI agent that is an expert in cell phone tower location data.
An expert's only as good as the data he gets. And remember, here we're talking about historic data. So it's not like they were pinging the phone. It wasn't real-time location data. This is just historic data, like looking at your phone bill after the fact.
That's scary. The defense alleges that the information does not provide a precise location. Based on the now well-established principles of historical cell site analysis and the general acceptance of this type of testimony by the courts across the country, there is no need for a Daubert hearing, and the evidence should be admissible. Courts have broad discretion to allow expert testimony concerning historical cell tower analysis because the technology and scientific principles used by the cell phones to communicate with one another are valid, reliable, and fairly easy to understand in layman's terms. The admissibility of expert testimony is governed by Arkansas Rule of Evidence 702 and the framework established by the Supreme Court in Daubert.
So Daubert is the Supreme Court case that deals with the admission of expert testimony, that it has to be reliable, it has to be based on accepted principles and foundation. This type of evidence generally has been, and maybe there's certain parts of it that should be called in question and require like a reanalysis. But once they let something across that gate, it's hard to get them to double back.
Yeah, to me, when the new technology surpasses the old should fall to the wayside.
Yeah.
That's
And
just the way.
again, we'll see how the defense specifically responds to these arguments in their reply right after this.
Right. So beginning in 1993, the Supreme Court provided trial courts with guidance on admission of expert evidence at trial. In Daubert, the Supreme Court established a two-pronged test for the admissibility of scientific evidence. The first prong rejected the widely used general acceptance test enunciated in Fry v. U.S., which is a 1923 case, a little long in the tooth there.
Right, and just to let
Decided,
them know, just for so people know, Fry and Daubert are the 2 Supreme Court cases that deal with this type of evidence, and the courts what they call gatekeeping function to decide whether something is good enough to be heard by the jury. There are states that are still considered Fry states.
yeah,
Most are Daubert, meaning they follow Daubert. Some are a hybrid, some are, a little of this, a little of that, and something different. So that's what they're talking about there.
yeah, like Indiana. I don't know what it is. It's neither really. I guess some form of hybrid. I guess they don't. I mean, I never even heard Daubert or Fry ever uttered during the entire Richard Allen matter, but there was definitely some tech,
Right.
but I don't know. So it decided a half century before the federal rules of evidence were adopted in favor of a more flexible standard that reviews the scientific validity and reliability of the evidence. The second prong, sometimes referred to as the relevancy requirement, simply reiterated that scientific testimony or evidence must assist the trier of fact in order to be admissible. It's kind of the key. So the trial court has broad discretion to determine whether to admit expert testimony and will not be reversed absent a clear abuse of discretion. See Hamling v. U.S. 1974 case. Any comment?
No, I mean, just because a court won't be reversed without a clear abuse of discretion doesn't mean they shouldn't, you know, possibly abuse their discretion, you
Right.
know?
Yeah.
But that's the rule, you know?
So, beginning in 93, the Supreme Court provided trial courts with guidance on admission of expert evidence at trial. In Daubert, the Supreme Court established a two-pronged test. Is there an echo in here?
Right?
For the admissibility of scientific
He's
evidence.
saying the exact same sentence
What
again.
the fuck is going
The
on?
first prong rejected the widely used general acceptance test enumerated in Fry, decided a half a century ago. Wait, did we somehow scroll up or did he literally repeat himself?
I don't know. What the
No, no, no,
fuck?
you went too fast.
I know.
Scroll.
Beginning in
Yeah, there you go.
1990. Wow. Wow. All right. So, look,
We're gonna skip this
they
second
were under
paragraph.
filing deadlines, they're rushing
Cutting and pasting shit.
and cutting it. Yeah, that still sloppy. Okay. All right. So here, this is new. The Supreme Court in Daubert listed 4 non-exclusive factors that are helpful to determine the reliability of scientific or technical testimony. 1, whether the scientific theory or technique can be and has been tested. 2, whether the theory or technique has been subjected to peer review and publication. Do you have any?
No, I was
I'm leaving you like a. I'm
because
leaving
I
you like
keep
a little.
chiming in.
Well, I love when you chime in. I just want to leave
I
you.
mean, the fact of the matter is that this stuff has been peer reviewed. It has been tested, but there have been new studies that call those older publications into question. And we'll see if that's what some of what the defense is arguing. Now, the defense is going to understand this evidence a lot more than Bob and I just going based on what they're saying and our general interpretation of historic cell phone data as opposed to real-time location data, precision location data, things like that. So we'll have to see how they respond.
All right. 3, whether a particular technique has a known potential rate of error. And 4, whether the theory or technique is generally accepted in the relevant scientific community.
And I'm assuming that's what the defense is going to argue, that the rate of error has been exposed to be different than it was, previously when it was admitted. But again, they know the specific evidence at issue, and maybe it's not exactly what I'm thinking it is.
Right. It's exciting to find out. So the court noted that these factors do not constitute a definitive checklist or test, and that many factors will bear on the inquiry. That involves a preliminary assessment of whether the reasoning or methodology underlying the testimony is scientifically valid, and of whether that reasoning or methodology properly can be applied to the facts at issue. Again, citing Daubert. So the inquiry to be undertaken by a trial court is a, quote, flexible one, focusing on the principles and methodology employed by an expert, not on the conclusions reached. Again, citing Daubert. Expert testimony, like all other admissible evidence, is subject to testing by, quote, vigorous cross-examination, presentation of contrary evidence, and careful instruction on the burden of proof, end quote. So the state provided Special Agent Downing's preliminary report to the defense. Downing is waiting on AT&T and Life 360 to respond to a search warrant on the Fosler phone's location data to complete his report. The defense moved to have the court exclude any supplements of data and expert testimony at trial. However, Arkansas Rule of Evidence 703 and 705 do not require that the state provides facts or data prior to hearing. So obviously, the prayer for relief is what they're asking for. The state of Arkansas respectfully requests that the honorable court deny Aaron Spencer's motion to exclude the evidence concerning the cell phone tower data. All right. So you want to go to the reply.
Defendant's reply.
All right. I might to exclude. There's a couple replies, and they're both pretty generic. I'm gonna have to pull them up.
I wonder if they had a warrant for that. If they're claiming that it can be precision location, then they might need a warrant. Where before, historic data, meaning like your cell phone bill and just what they kept in the normal course of business, wasn't subject to the fourth because it didn't give all that much information. But now they're claiming that it can give you their precise location. So that should or could give rise to a Fourth Amendment, privacy issue. I don't know.
All right, I found it. I did it. All right, so this was filed December 10th, and this is the brief accompanying the reply in support of the defendant's motion to exclude evidence concerning the cell phone tower data. You wanna give this one a go? I can scroll for you. Can you read it?
I can just make it bigger, yeah. Okay. The defendant, Aaron Spencer, buying through his attorney, Aaron Casanelli, and Michael Kyle Kaiser of Lassiter and Casanelli, submit this brief accompanying reply in support of the motion to exclude evidence concerning cell phone tower data. The state misapprehends the basis of Spencer's motion. The issue is not whether cell tower analysis can ever be reliable under 702. The issue is whether the state's expert can apply that methodology reliably to the facts of this case, citing Rule 2, Daubert, Joyner, Kumo, Tyer, and Arkansas precedent all require the trial court to determine whether the expert's reasoning and methodology are, one, valid, and two, properly applied to the facts of its case, the facts in dispute. Here, they are not. Applicable law. Arkansas Rule of Evidence 702 governs the admissibility of expert testimony. The rule states that if scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact at issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify hereto in the form of an opinion or otherwise. Application of this rule requires a trial court to make inquiries as to both the helpfulness of the proposed testimony and its methodology, validity. I lost Yeah.
Sorry.
Oh, methodological. My God, methodological validity. Okay. As the court explained in Daubert, faced with a proffer of expert scientific testimony, then the trial judge must determine at the outset whether the expert is proposing to testify to one, scientific knowledge that two, will assist the trier of fact to understand or determine a fact at issue. This entails a preliminary assessment of whether the reasoning or methodology underlying the testimony is scientifically valid and whether that reasoning or methodology properly can be applied to the facts at issue. In Kumho Tire Company Limited, the United States Supreme Court addressed the question of, quote, how Daubert applies to testimony of engineers and other experts who are not scientists. It
Which
concluded,
Fed is not.
right, it concluded that Daubert's general holding, setting forth the trial court's general gatekeeping obligation, applies not only to testimony based on scientific knowledge, but also on testimony that is based on technical and other specialized knowledge.
Sir,
As
are
the
you a wizard? Okay.
As the court explained, we conclude that Daubert's general principles apply to the expert matters described in Rule 702. The rule, in respect to all such matters, establishes a standard of evidentiary reliability. It requires a valid connection to the pertinent inquiry as a precondition to admissibility. And where such testimony's factual basis, data, principles, methods, or other application are called sufficiently into question, the trial judge must determine whether the testimony has, quote, a reliable basis in the knowledge and expertise of the relevant discipline. And then quoting Daubert. In a parallel to Daubert, the Arkansas Supreme Court embraced the Kumho holding in Coca-Cola Bottling Company of Memphis, Tennessee v. Gill. That's in 2003. The court noted that under Foote and Daubert, the circuit court must make a preliminary assessment of whether the reasoning or methodology underlying expert testimony is valid and whether the reasoning and methodology used by the expert has been properly applied to the facts in the case. Rule 702 guidelines apply equally to all types of expert testimony and not simply to scientific expert testimony, citing Kumho Tire. Fulfilling the trial court's gatekeeping function will at times involve analyzing the logical link, or lack thereof, between data and an expert's opinion. A court may and should inquire into not only the type of material upon which an expert relies, but also whether the material actually supports the expert's reasoning. Quote, trained experts commonly extrapolate from existing data, but nothing in either Daubert or the federal rules of evidence requires a district court to admit opinion evidence that is connected to existing data only by the ipsa dixit of the expert.
Ipsy Dixit rearing its ugly head once again.
Yes. So they're saying,
Hey,
look,
I said so, bro.
call him an expert, have him make some like logical leaps or illogical leaps on the data. That doesn't make it right. We have
Trust
to
me,
know.
bro.
Right. I said so.
Trust
I
me.
said so. I looked at the data and I said so.
I'm never wrong. Trust me, bro.
A court may
Hey, we're
conclude.
good. We're good. He said, trust me, bro. He's never wrong. We're good.
Yep.
Admit
A
it.
court may conclude that there is simply too great an analytical gap between the data and the opinion proffered, citing a Supreme Court case and then a Sixth Circuit 1992 case. Arkansas has recognized the importance of a trial judge's gatekeeping function and has embraced the analysis set forth in Daubert, Kumho, and Joyner. In Wood v. State, for example, the court emphasized the essential role that trial judges have, quote, as evidentiary gatekeepers for ensuring the reliability of proposed expert testimony, citing an Arkansas 2001 case. The court further emphasized that the trial judge has a threshold responsibility to determine, quote, whether the reasoning or methodology underlying the testimony is scientifically valid and whether the reasoning or methodology properly can be applied to the facts at issue, citing the Daubert. And, quote, a primary factor end quote, to be considered in determining whether scientific or other expert evidence is admissible, quote, is whether the scientific theory can be or has been tested. Citing again back to an Arkansas case citing Daubert and also Farmer
Bureau.
Bureau Foot, $2,000 federal case, I think.
$2,000.
Right? No, maybe
Here's
it's
the thing that I've got an issue with a Fed who, clearly can read a phone bill, right? The problem is this Fed going to be able to explain the methodology? Because it's like I'm trying to remember
well,
what
they're gonna
really
talk about a thing, and it bounces off of the thing, and it goes here, and it goes there, but do they get enough information to say that from the historic data?
I'm
Like,
getting like Trooper Paul vibes. Like,
yeah,
do you remember him trying to explain the methodology? I mean, he didn't even know basic physics,
right.
but like if they get into the weeds in
That was some
terms of
Ipsit-Dixit.
that, well, there was a lot of Ipsy Dixit in that case, but here, I just don't know. And I don't know anything about Agent Downing. Maybe the guy is learned in the ways of cell tower beyond just being able to, parse the information and regurgitate it. But I mean, to me, there's got to be an ability to be able to explain the data beyond what he's interpreting it as, meaning, how does the shit work?
Right. At the end of the day, the judge is gonna let it in and tell the defense, put on another expert to tell why this is wrong.
Right.
Joyner further instructs that courts may exclude expert opinions when
Hey, you skipped the whole first part, bro.
oh, I did. Okay, sorry. One. All right, so argument 1,
Jumpy.
Rule 702 and Daubert requires reliability in method and application. And that's a lot of what their focus is here, is how they applied it here. Under 702, no, sorry, go back up.
Whoop.
Under 702 and Daubert, the trial judge must determine whether the proffered testimony reflects 1, genuine scientific technical knowledge, and 2, a reliable application of that knowledge to the facts, citing to Daubert. Kumho-Tyer extends this requirement to all forms of specialized knowledge. Arkansas imposes the same gatekeeping obligation. Joyner further instructs that courts may exclude expert opinions where there is, quote, too great an analytical gap between the data and the conclusions offered. That is precisely the problem here. Section 2, there is an analytical gap between cell tower data and the state's conclusions. Did I miss a footnote?
No.
Oh, no, it's
No,
there.
it's
Okay.
coming.
The
Coming.
state's expert attempts to use cell tower connection records to infer precise locations of the relevant phones. That methodology is not supported by the data. While cell tower analysis can sometimes identify a broad service area, it cannot pinpoint a phone's location within that area as the state's expert reports to do so. Footnote.
41.
Yes. Additionally, the state has not produced all of the data its expert relied upon to generate the opinions outlined in his report.
Trust
It
me,
pro-
bro. Trust me.
produced AT&T records, but these records are missing a necessary component required for the state's expert to create the diagrams referenced in his report to show geographic areas. This data will be necessary for the court to evaluate whether the expert reliably and properly applied the theory to the facts of this case.
Defense.
All right, it's covered by the
Oh.
defense. The defense requires this
Well,
information to fully present the issues raised herein and to demonstrate the unreliability of the proposed testimony. So this is what I was saying earlier. Like, that's my understanding, at least, of historic cell phone data, is that it cannot give a precise location. It can just give a general geographical area or tell you which tower something picked up the call, but that doesn't even necessarily mean they're in that's the closest one to their geographical location, because there could be some like interference, there could be weather, there could be, who knows what.
all kinds of shit. And it also goes back to the other thing that you said, which is your predictive, which is that the judge is going to say, you know what, here's the deal. I'm allowing this in. You get your expert to put on why this expert's testimony is all bullshit.
But
Which is
I
exactly what's
think
going
it's
to
the
happen.
wrong decision, by the way, only because I do think it's established that historic cell phone data cannot provide precision location information.
Which would make it tasty for a Daubert, because that's when the defense would put their expert on to say, okay, judge, this is why you can't even allow this testimony to come in, because you're gonna pollute the jury's mind with this bullshit on the front end, and then you're gonna expect me to come in and try to undo it when they've already, set the die.
Right.
in
The
the
defense
jury's
is saying,
mind.
"Hey, sure." The prosecution's trying to tell you this data it's been dauberted. It's been found reliable. It's been
Yeah.
allowed in all these courts. Yes, but not for at least to my understanding and to what it seems the defense is saying here, not for precision, precise location information. And that's like the prosecution, I think it's like the prosecution's trying to pull the wool over the defense's eyes. But again, I haven't heard like know exactly what the expert is saying. I haven't researched, um, the historic cell phone data in some time, but it seems like that's what the defense is saying here as well. So I think,
Yeah, and look, Allie and I are not privy to any of the discovery in this case. So, in terms of why the defense is filing this particular motion in light of what we kind of do know factually, is that Aaron left the house. He ends up finding Fosler driving, turning onto the road that they live on, and follows him for 6 miles, where, he pushes him off the road, gets out of the truck, shoots him dead. So, I mean, like, we
I think
know the
this is
general location in terms of where people are. But my point is, I don't know that this is some kind of death knell type motion in terms of what the defense is thinking if the judge allows it in. You know what I'm
right.
saying? Because, like,
It's
sometimes you just file motions because you'd like to be able to keep it out. But in
right. You're
terms
going to
of, is
try
it going
anyway.
to be of great importance in terms of pushing the case one way or the other in the minds of the jurors? I don't know. It doesn't seem like it to
Right, I
me.
think if I remember correctly, this was more about, like, where they claim he was, like, when he answered the call from his wife, where they claim he was, like, I think it
And again, like, that shit doesn't really matter to me. Like, in terms of, the panic of the 6 mile high speed chase.
right,
Like, I don't care where he's at, where when he's calling his wife, or why he doesn't call 911. Like, who gives a shit?
right.
Like, I'm just talking about, like, bigger picture type things. Like, I don't think that this particular motion is, like, there's motions that we file where we're like, look, if we don't win this motion, we're fucked.
Right.
That kind
Like,
of.
you gotta plead out. We
Right.
lose this, you gotta plead. This is
Right.
your last.
This is not that, I don't think.
No,
But
no, nothing's that in this case, but this is not as
right,
right. Point taken, this is not that,
right.
like, gonna make that huge of an impact. Alright, returning to the body. The method is inherently imprecise. Towers overlap. Load balancing occurs. Environmental conditions vary, and carriers routinely warn against using tower connections for grained
Fine.
fine-grained
Yeah.
geolocation. Thus, applying the method to determine exact or near exact location creates the very type of unreliability Daubert and Joyner prohibit. It is an opinion that, quote, extrapolates beyond the data.
Extrapolates.
Extrapolates beyond the data. What did I say?
Extrapolates. It's
Oh,
extrapolate.
extrapolates.
Nope. Oh,
Extrap what?
extrapolates.
Extrapolates.
It's kind of like
Extrapolates.
your bicep.
Yeah, my bicep. I'm gonna come over and smack you with my bicep.
Yeah, I bet you are.
Okay. Extrapolates be
Nailed it.
beyond the data and invites the jury to rely on ipse dixit rather than science, citing back to Joyner. 3, the offered testimony provides no help to the jury and risks significant misleading prejudice. Rule 702 requires that expert testimony, quote, assist the trier of fact. The state's proposed testimony does not for the following reasons. There is no dispute about the general area where the phones were located, which is the only level of location accuracy cell tower data can reliably offer.
Gee,
I would
that's
have
what I was saying.
put in there historic cell tower data. The experts attempt to go further to suggest precise or near precise location is methodologically unsupported, speculative, and contradicted by industry guidance.
Methodologically.
Methodologically.
That's a mouthful.
Methodologically.
There you
Because
nailed it.
because the testimony purports to offer precision, it cannot actually deliver. It is not merely unhelpful. It is not merely unhelpful. It is affirmatively misleading. Arkansas courts have recognized that unreliable expert testimony must be excluded because juries naturally place disproportionate weight on expert opinions, especially when presented with maps, graphics, or, quote, heat circles, implying a level of accuracy the method does not support. And this goes to exactly what you were just saying, babe. And they quote back to Wood, talking about how Wood emphasizes the gatekeeping role. They cite back to Foote that a trial court must prevent unreliable methodology from reaching the jury. Even if the expert acknowledges limitations on cross-examination, the visual and scientific trappings of his testimony risk misleading the jury into believing the testimony is more reliable than it is. That is precisely the prejudice Rule 403 and Rule 702 are designed to prevent.
You know what I'd like to see the cell phone data location for? Like where the cops were when Heather calls as he's pulling out of the property, and then ensues in this 6-mile chase. Where are these cops? Like it seems like to me that they would have like there's not like a ton of roads in this area. I've kind of looked at a map. I mean, yes, there's a bunch of small roads, but in terms of kind of like state highways, there's only so many, and they have a starting point of the Spencer's house. They kind of probably have an idea of how far along Aaron Spencer could be. Like, where were these dudes? Like during this time when he's chasing Fosler, I'd love to know where they are. They're pointing the finger at Aaron saying, "Hey man, you should have really called 911." Well, where the fuck were you? We did. We called before she's opening the gate to let me off the property, and she's on the phone with y'all. Where were you? You knew I was out there looking for him. Where were you? Like, I'd love to see that information. To me, it's relevant. If they're going to sit here and say, why didn't Aaron Spencer call 911? Well, we did, bro. Where were you? I'd love to see that. It's not going to come in, but I'd love to see it.
I was
I'm
just
done.
looking at a case that I'd pulled up about precision location versus real time, because all right, after we finish this, I'll read it to you guys. All right, section 4.
I think you had the very end of it was this last paragraph.
No, I read rules 403, 407 are designed to present. Section
Oh.
4, because the method is unreliable.
Sorry.
Scroll up a little bit because I have it blown up on my end. Because the method is unreliable as applied here, the cell tower testimony must be excluded. The state cannot cite a single case holding that cell tower data is admissible to establish a phone's precise location within a multi-mile area. To the contrary, courts repeatedly warn such uses are speculative. See generally case and law review articles cited in defendant's motion. When methodology cannot be reliably applied to answer the specific factual question issue, it must be excluded, citing back to Daubert and Kumo. For these reasons, the state's proposed cell phone testimony must be excluded. The state has not shown that its experts' methodology can be reliably applied to the facts of the case, and Rule 702 does not permit opinions built on analytical gap the size presented here. On analytical gap, the size presented here. Allowing the testimony would mislead the jury, invite speculation, and undermine the court's gatekeeping role under 702. The court should therefore preclude the testimony in its entirety. And I did a quick search, so I'm not going to read all of it right now, but this is uh, well,
Mm, mm.
so I thought I had a 2020 case. This is like 2013, and it says, as in the instant case, prosecutors may wish to present evidence of a site to which a defendant's cell phone connected in order to prove the defendant was near that location at a certain time. However, the problem with using historical cell site records under this evidentiary theory is that they were never intended to and do not indicate location of the cell phone in relation to any cell site. At best, these records can only narrow locations to a geographic coverage area of the originating and terminating cell sites rather than pinpoint the specific location of the cell phone. It cannot be determined that the cell phone was closest to the site processing the calls because factors other than geographic location can affect signal strength. And that's
What
2013.
state?
It's a Missouri federal case, and they have a footnote that says tracking cell phone location by real-time triangulation or GPS, more precise methods are beyond the scope of this discussion.
Yeah, and see, that's the thing. The way that technology works and the advancements that we've had, like when you think about where AI was a year ago and to where it is now, the same thing applies to any tech that we're using these days. When you're talking about a 12-year period of time, in terms of the devices themselves and all the technology that surrounds it in terms of trying to be able to geolocate people has gotten so much better. Like to me, when it comes down to this kind of tech, there has to be like if Judge Elmore is going to sit there and be lazy on this shit and rule on the papers just because she doesn't want to conduct a Daubert, because really, like I want you guys to understand, a Daubert is essentially a battle of experts. Essentially, what would happen is the state would say, okay, well, here we're going to put on our Fed. This is what he's going to say. And then the defense is going to say, okay, and they'll get to cross-examine him. And they'll say, okay, well, what's your methodology? How did you arrive on this particular information? And like try to get him to explain that he has an understanding how it actually works. And then they theoretically would put on an actual expert who really does understand how it works. And they would come on and say, okay, well, this is why we can't trust this. This is why you can't present it to a jury. It's one thing to say, okay, well, we're going to let him get on and say what he's going to say. And then, you're going to let me come on and say what I want to say. Well, the damage has been done. You're presenting something now. Now it's a battle of experts, which a lot of times just X one another out, which shouldn't always be the case. If one expert's giving bad intel or old intel or outdated intel, and you have somebody who's going to teach the jury, okay, look, this is what's accurate, and what this guy told you is not accurate. You shouldn't even been told what it was because it's completely inaccurate. That's bullshit. Like this is something that should be fought prior to trial. This is information from the state's perspective, in my estimation, that shouldn't even be brought in front of a jury for them to have to rebut it. And I'm talking about the defense because they have to wait. Remember, the
Right.
state always goes first.
And here's
Everything has
just
its opportunity to just sit there and percolate in the minds of the jurors. So their story is the one they hear first. You've got to wait all the way until the defense's case in chief. Then they'll call their expert. At that point in time, shit's already set in. People are already making their minds up on things. Timing's everything in this world, and that includes in the court of law. So for me, this is something where I think it warrants, because of the advancements are so rapid in the technology world, that they should have Dauberts left and right on this shit.
right. I agree that there needs to be a Daubert here because the way they're trying to apply it. Now, just to read you some quick head notes from a 2019 case, and this is in a state case in Colorado. Expert testimony explaining how historic cell site data is used to provide general geographic location of a cell phone at any given time may be admitted without holding an evidentiary hearing on reliability of methodology. where use of historical cell site data to determine general geographic location of a cell phone is widely accepted as reliable. Now here's another one. Prosecution's use of historic cell site data through an expert to determine general geographic location of defendant's cell phone at the time of the offense was in the bounds of reliable historic cell site analysis and thus was admissible in prosecution for kidnapping, burglary, blah, 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 blah. Prosecution's experts generally explained how cell towers work and identified variables and limitations incorporated into their analysis. One expert identified which of the defendant's calls used which tower and sectors. Another expert opined that it was not feasible for the defendant's phone to have been 18 miles away at the time of the offense. And neither expert opined as to precise location of defendant's phone at any specific time. So, there's one more that says, while assumptions and variables may be tested by vigorous cross-examination, they do not render the fundamental methodology of an expert's cell site analysis unreliable. Now, just based on that right there, it tells you, hey, they're not trying to use this to give a precise location. So they're just trying to prove this guy wasn't 18 miles away. He couldn't have been that far away and it still picked up on these towers. So they didn't require one. So, I'm assuming that it is, if we've got a good judge here and she reads the law, she's going to see that it's been, forever. They've said that historic cell site data cannot give precise location data, period.
Yeah, well, I think we all know what type of judge we have here. Yeah, and DB, you nailed it, man. I mean, this is exactly what I'm talking about. So DB's like, well, the FBI CAS team will go up there for 4 hours with PowerPoint and a sharp haircut and use a ton of technical terminology and make everyone think, wow, these guys really, really know their stuff. Like, and that's exactly what I'm talking about. Like, how do you undo that when you have
Right.
to wait till the defense's case in chief before they put somebody on to rebut? The shit's like already set in. It's like it's germinating in their brains. They're already
And,
forming their opinions. So yeah, that's
and again, they might be using something more than what has typically been referred to as historic cell site data, but it
I
doesn't
mean,
seem
I
that
didn't
way.
get that impression, yeah, from
Right.
motion.
All
All
right.
right.
So move on to the next state where there's a reply, and that's the one that has spoliation in it.
Yes, this is the one. Okay. So this one, this one pisses me off. So this thing was filed. This was the first response that the state filed. We had gone over the original motion. It's when we learned about Fosler had dashboard cam in his truck, which has all been lost. All the data was lost.
Oopsie.
Oops, sorry.
Uh-oh.
All right. So the defense was obviously upset with the fact that they had lost this particular information. And this is the state's brief in response to the defendant's motion for adverse inference, jury instructions, and a hearing on the spoliation / destruction of evidence. All right, so this is the prosecuting attorney coming through again, and this is their intro. So during the homicide investigation of Aaron Spencer, the Lono County Sheriff's Office, the LCSO, discovered a dashboard or a dash cam that was mounted in Michael Fosler's truck. Detective Robbie McCain with the LCSO later found that the dash cam contained a removable micro SD card. McCain removed the micro SD card and personally reviewed the files it contained. This is where
And created a corresponding police report because it contained nothing? Oh, this is bullshit. I write a police report about it. There's nothing on here.
Explodes on this thing. The guy, like his computer, like I want to see proof. I want to see proof that this guy took the micro SD card out, plugged it into his computer, or put it into whatever you have to put it in to read in that.
If you watched it, in my opinion, if he watched it and it didn't, and it was helpful to the prosecution, he would have drawn up a report that said so.
Yeah.
The fact that they're like, oh fuck, we better send this to the states, to the
lab or whatever.
No, they went to the Attorney General's office to review. Says they were freaking out about it. Like, oh fuck, we better send this to the Attorney General's office.
Okay, so he reviews the video files it contained. He noted that all the files showed a camera angle facing forward with flashing blue and red lights in the background. These flashing blue and red lights were apparently from the police cruisers and ambulance parked on the road behind the truck for several hours while the investigation was underway. Detective McCain later returned the micro SD card back into the dash cam and packaged it to be sent over to the AG's office along with other electronic devices, such as
Yeah,
what?
and where are his notes? Where's his report?
What else did you send? What
Yeah,
other electronic
what's
device?
all this shit?
What is this shit you speak of? What are these other devices? Like that right there. I can't wait to see what the defense says. What other electronic devices?
Maybe they know what it is.
Curious. Maybe they do. Maybe they don't. Forensic examiner Amber Calmer with the AG's office received the dash cam. However, it did not contain the micro SD card. What? LCSO has made several attempts to locate the SD card, but it has not been found. See his affidavit. Oh, I can't wait to read that. The defense asserts without proof that the Lonoke County Sheriff's Office acted in bad faith by inadvertently losing a micro SD card that contained no exculpatory evidence. How do we know that,
Because
sir?
I said so,
Trust
sir.
me, bro. Trust me. There was nothing. I have a badge, bro. Do you see this badge?
Right?
Trust me. Are we clear? Are we clear? Do you see the badge? But the badge.
I took
The
an oath.
badge. Do you see the badge?
I'm
The defense
sworn.
ignores established Arkansas law that places the burden on the defense of proving bad faith. Wow. And that's footy one. So the defense motion goes even further, suggesting that Detective McCain may have committed the criminal offense of tampering with physical evidence. oh,
How dare he?
a cop would never do that. The claim is wholly unsupported, and the defense offers no proof. How the fuck do you suggest the defense get that, State? How are we getting proof that you guys are scumbags? Are you going to let us back to creep around in your offices there? Can I dip into McCain's
Can we watch some of your
computer there?
recordings?
Can I check that out?
Yeah, let
Can I
us
get
do
some of the? You guys have video in your police station? Is there some shit like that catches you guys at your fucking cubicles doing shit? I'd like to see all that, and then I'll prove it.
Well, show me the metadata, please.
I want to see the metadata. So the claim is wholly unsupported, and the defense offers no proof that McCain altered, destroyed, suppressed, removed, or concealed the SD card within the meaning of the statute, nor that he acted with the requisite criminal intent. The defense argument would lead to the absurd result of creating a criminal liability on behalf of any law enforcement officer performing their normal job duties while investigating a crime and losing critical evidence. Like what is that?
Keep scrolling just to make sure. Okay, go back up.
All right. Where was that footy? Where were you? Okay, there. Argument. An adverse inference jury instruction is inapplicable in this instance. Arkansas courts do not apply civil style spoliation instructions in criminal cases. No Arkansas appellate court has ever approved an adverse inference spoliation instruction in a criminal case. In fact, the court in Autry v. State, the only Arkansas criminal case cited by the defense, denied the defendant's requested jury instruction on spoliation, explicitly stating that giving the jury the ability to infer that evidence destroyed was unfavorable to the party responsible for its spoliation, quote, is not the law in criminal cases.
Yeah, that's a 2005 case. The Supreme Court case law has changed since then.
Furthermore, the model civil spoliation instruction has no counterpart in the Arkansas model criminal instructions. Our Supreme Court affirmed the denial of such an instruction because it conflicts with controlling constitutional law. The court found that the proposed instruction in Autry contradicted with Arizona v. Youngblood in 1988.
Was in contradiction.
Was in contradiction with. So in Youngblood, a spoliation instruction was given at the trial level, but it was not adopted as the appropriate remedy by the U.S. Supreme Court. Instead, the court added the requirement the defendant show bad faith on the part of the police to prove a due process violation based on the destruction of potentially useful evidence. Arkansas courts have followed Youngblood in their opinion. See Wenzel, Supra. In Spencer's case, there is no proof of bad faith on the part of the Lono County Sheriff's Office in the inadvertent loss of the SD card. A bare contention of bad faith without supporting facts does not demonstrate that the state acted in bad faith in destroying evidence. There is no support for the defense's assertion that recklessness, which was not the case here, amounts to intentional destruction of evidence. A bare assertion of bad faith without supporting facts does not demonstrate bad faith. B, the inadvertent loss of the SD card does not amount to a Brady violation. Under Brady, it is a violation of due process when the state suppresses evidence that is material to guilt or punishment. To establish a due process violation when potentially useful evidence is destroyed, the defendant must show that the evidence possessed exculpatory value, which would be really hard here since we don't have the fucking video. That was evident before the evidence was destroyed and is of such a nature that comparable evidence could not be obtained by other reasonably available means. I cannot think of a more important piece
Right.
of fucking evidence than this clown's dashboard cam, which
That
we all
cannot be
know
replaced.
recorded everything. It recorded the entire fucking thing, all of it. So,
oh no, Bob! It just recorded the cops behind his car.
woo, woo, just the red lights, the red and blue flashing deep in the night. In addition, unless a criminal defendant can show bad faith on the part of the police, failure to preserve potentially useful evidence does not constitute a denial of due process of law. Quoting Arizona, for instance, in Long v. State, an Arkansas case, the Arkansas Supreme Court held that the inadvertent deletion of body cam footage did not amount to destruction in bad faith. Pull that case up, babe. The court held that the defendant failed to show that body cam video of a search was potentially exculpatory and that it contained evidence that was unobtainable by other means, such as witness testimony. What, the testimony of the cops? Or the fucking people's house who was being searched and they're like shell-shocked and mortified and stuck on a couch in handcuffs. I don't know, man.
Wait, Long v. State 2024?
It's an Arkansas case. I don't know. They didn't
I-
give a year.
No, I think it said 2024, I thought. Wait,
No, I don't see.
where'd it go? Wait,
I had it here. There's no year, bro.
2024
Where do
ARC
you see
App
that?
98. 2024 ARC App 98.
Oh, yeah, there it is. Is that they put the year?
Yeah.
Oh.
See how long it's been since you're researching cases.
I mean, I've never seen the year there. I always see it at the end, typically. The Arkansas Supreme, it's been a minute though. The Arkansas Supreme Court held that the inadvertent deletion of the body cam footage did not amount to destruction in bad faith. The court held that the defendant failed to show that the body cam video of a search was potentially exculpatory and that it contained evidence that was unobtainable by other means, such as witness testimony.
I
Additionally,
bet you that destruction was like under the normal course, but I'm reading it now.
So additionally, because the defendant could not prove bad faith, she did not prevail on appeal. Here, Spencer has failed to show that the video contained on the SD card was potentially exculpatory. It's such that argument is so frustrating, and that it contained evidence that was unobtainable by other means, such as the evidence is in question is obtainable by witness testimony. Whose testimony?
So
Aaron's?
in Long v. State, right? Yeah, Aaron's testimony in Long v. State, that was they said it wasn't unobtainable by other means because the officer could have testified to it because it was his body cam.
I mean, in theory, this thing goes right to the heart of the case. In theory, this video would have shown Fosler whether or not he got out of his truck, whether or not he had something in his hand. I mean, this is an insane argument. Like I honestly don't know. Well, we'll have to get to see what the defense is really asking for here. So further, there is a sworn affidavit from Detective McCain as to what was contained on the SD card. The only proof of bad faith is the defense's bare assertion. So, conclusion and prayer for relief. For the foregoing reasons, the defendant's request for an adverse inference jury instruction and a hearing on alleged spoliation should be denied.
Yeah, I mean, this is a 2024 case that seems to be using like the same type of arguments, you know, saying that with Brady, it doesn't matter if it's good or bad faith, but you have to know that the evidence is exculpatory and like
What were the facts of the case? So, like,
it was that they deleted body cam that he's saying would have proved that they didn't have the stuff, and the cops saying, you know, but they're citing this Wenzel case from 1991. They're talking about Arizona v. Youngblood, um, requiring that, and they said where the failure to when there is a failure to preserve, I don't know, potentially useful evidence, this does not constitute a denial of due process of law unless the defendant can show bad faith on the part of the police. You know,
I mean, in a search warrant thing, I mean, like, that would be the defendant saying they planted the shit. Yeah, that shit wasn't in my house. The fucking video would have shown it and they lost it type argument. This is a different thing to me. Okay, so Arkansas law is clear that adverse inference instructions are not permitted in criminal cases, and the defense has offered no evidence beyond unsupported allegations to meet its burden of showing bad faith under Youngblood and its Arkansas progeny. So the record establishes that the SD card's loss was inadvertent and that its contents were neither exculpatory nor unobtainable by other means, and that comparable evidence is readily available through witness testimony. Because the defendant has failed to demonstrate either bad faith or a due process violation under Brady, his motion should be denied in its entirety. Okay, so let me see.
so and they do talk about how, and this again is 2024 case that um the spoliation instruction is limited to civil and there's no criminal counterpart.
Okay, all right. So you're up.
Um,
Filed December 10, 4 pages in length. This is the brief accompanying the reply in support of the motion for adverse inference jury instructions and a hearing on the spoliation destruction of evidence.
Okay, defendant Aaron Spencer Bine, through his attorney, submits this reply in support of its November 25th, 2025 motion for adverse inference jury instruction and for an evidentiary hearing on spoliation of evidence. The motion stems from the Lonoke County Sheriff's Office's loss of a memory card containing dashboard camera recording from Michael Fosler's vehicle. As alleged in the motion, the LCSO seized a dash cam that would have recorded critical exculpatory evidence and then failed to secure it, failed to follow basic evidentiary handling procedures, unnecessarily removed the SD card, mishandled it, and ultimately lost it. The state's The state's December 3rd, 2025 response and accompanying affidavit. Oh, was the affidavit not attached?
I didn't see it.
Check the motion.
Let me
Check
go
the
back.
motion. Let's
Let
just
me go
pause
back.
because I only gave you the.
All right, let me see.
No. You got to look in your email. I'll check
Wait.
it. You check
Wait.
that. I'll check the motion itself.
Yeah, I definitely saw an affidavit. I don't know if it was
Right.
attached.
So remember what I said? We did. I only put in the briefs. It might be in the motion. So let me
Oh,
go back to Tracy's emails because that actually could be an issue here. The states. No, wait.
good old John Staley.
Okay, here it is.
AT.
No, this is the state's brief again.
A little light.
Oh, no, here's the affidavit. All right.
Good.
What were you but this says that it's the state's brief.
What do you mean?
I don't know. It's like we're looking at the same thing, but you don't have it. All right. I'll share it.
Oh, so wait, you're seeing the affidavit?
12/4/25 state's brief. You know why there was a yeah, right there.
Yeah. I mean,
Yeah, you should have it. It's 8 pages. There it is.
what the fuck? What were we just reading?
I don't know, but go ahead. Affidavit.
Okay. So this is the affidavit of Detective Robbie McCain with the Lonoke County Sheriff's Office. After having been duly sworn, did make the following statement under oath. I am employed as a detective with the Lonoke County Sheriff's Office. That on October 8th of 2025, while investigating a homicide in Lonoke County, I located a dashboard or a dash cam in a Ford F-150 belonging to the deceased, Michael Fosler. The truck was in the process of being towed from the scene. I secured the dash cam and placed it into a manila envelope along with other evidence found at the scene. While looking at the dash cam, I noticed that the dash cam had a micro SD card inserted in it. I took the micro SD card out of the dash cam and placed it into an adapter for a regular sized SD card. To view the files, I placed the SD card into a card reader and opened it on my computer. The SD card contained 4 files, and I reviewed each one. The only thing can be seen is a forward-facing view from Michael Fosler's truck, showing the tree line in front of where the truck came to rest. All that can be seen on the videos are flashing blue and red lights. The first 3 videos were approximately 15 minutes long, and the fourth was less than 15 minutes. I pulled the SD card out and placed the micro SD card back into the dash cam and placed it back into the original manila envelope. The dash cam was then sent to the AG's office for further analysis. Sergeant Carla Lucas transported the dash cam to the AG's office. I learned that the micro SD card was not in the dash cam from Special Agent Amber Calmer. I then searched the LCSO CID office for the SD card and could not find it. Sergeant Lucas's vehicle in which the dash cam was transported was also searched. The micro SD card has not been found.
I negligently and recklessly failed to make a backup of it. I failed to make a police report, a report of what I watched. I don't even have notes, my handwritten
I
notes.
unilaterally decided it was worthless. So there you go. Trust me, bro. I have a badge. Okay, let's go. Let's keep rolling here. Okay. Let's get back to the defense. Okay. Reply.
Did that thing say the 12th of December?
What? The affidavit?
Yeah, it doesn't matter, but
I don't think so. It had to have been the 4th, right? Because it was filed on the 4th.
it's
Unless they filed something after with the affidavit, but that seems crazy.
no, yeah, I must have been looking at it wrong. All right. The motion stems from Lonoke County Sheriff's Office loss of a memory card. Okay, I read this one and ultimately lost it. The state's December 3rd response and the accompanying affidavit of Detective McCain fail to acknowledge the technical impossibility of McCain's version of events.
Impossibility.
The state also fails to acknowledge that, unlike in cases cited by the state in its brief, here, law enforcement acted contrary to its policies. Right, exactly. Because the factual contradictions at issue here, the court should grant Spencer's request for an evidentiary hearing to further develop the basis for spoliation sanctions. Argument. Following the filing of Spencer's motion, defense counsel tested the dash cam recovered from Foster's truck and verified that the state's version of events is technically implausible.
Implausible.
See the affidavit of Jason Stachy. The visit further confirmed that Detective McCain did not follow LCSO policy, acted contrary to his training, and handled the SD card in a manner inconsistent with agency practice. 1. Technical testing contradicts Detective McCain's affidavit. The functional testing of the dash cam contradicts Detective McCain's statements in several material respects. One, powering down does not erase files. Testing shows that turning the dash cam off stops recording, but does not delete the existing footage, contradicting Detective McCain's belief that unplugging the device wipes the card. I do remember reading something like that. Wasn't in what you just read, though, right?
No.
But I do remember us reading that in something before that the state filed. I don't know. All right. 2, dash cam records both front and rear. The dash cam records 2 streams at the same time, front and rear. Detective McCain's sworn affidavit that he observed only forward-facing files on the SD card cannot be reconciled with how the device operates. 3,
Oopsie.
dash cam creates multiple directories for front and rear recordings. Now, this deserves an affidavit by someone. All of this, by the way, like if it has a front and a back, and the defense should be putting together something that proves that, somebody that says that, even if it's their investigator saying, I read the.
Well, I think there is. Then they say that there's
Well, they're not citing one for these assertions right here, so we'll have to see what's in. We'll have to see what's in the affidavit, I guess.
Yeah.
3, I don't know if I read 3. 3, dash cam creates multiple directories for front and rear recordings. The dash cam creates multiple directories to store its recordings from front and rear cameras. Detective McCain's claim that he saw only 4 files, all forward facing, is inconsistent with the dash cam's normal operation. 4, G sensor would have locked the relevant footage. The same impacts that trigger the black box event in Fosler's truck would also have triggered the dash cam's G sensor, locking the recording from both cameras and preventing them from being overwritten.
The old G sensor.
That G sensor.
Oh,
The
boy.
state's assertion that the dash cam contained only recordings, quote, made after the incident is incompatible with the device's design, which simultaneously records 2 views, stores them in separate directories, locks files for further during shock events, and retains locked files even through loss of power. Section 2, Detective McCain violated LCSO policy and his training. As detailed in the affidavit, Exhibit A, Detective McCain's actions were inconsistent with his training and LCSO policies. 1, failure to document evidence before removal. The dash cam was not photographed, measured, sketched, or otherwise documented while still mounted on the truck, contrary to LCSO's policy 16-1. Okay, I'm not so moved by that one. 2, improper removal causing damage. Detective McCain removed the dash cam with enough force to break its mount, violating the requirement to preserve evidence in its original condition. Again, doesn't deal with the actual SIM card. 3, the failure to separately mark and track evidence. Here we go. Once Detective McCain removed the SD card from the dash cam, he should have photographed, marked, and sealed the card in a separate envelope and tracked it through the evidence system. None of these steps were followed. That, you can argue, was a contributing factor in how the hell this thing came to get lost. Nobody even knew to be paying attention to it. 4, failure to
stuck it back in the dash cam.
Yeah. 4, failure to secure evidence containers. Evidence envelopes were sent to the Attorney General's office unsealed and merely clasped, which does not comply with the requirements of proper evidence security or LCSO policy, especially when containing small items like an SD card. That one's at least on the right, the right area.
Yeah.
5, violation of agency practice and officer training. LCSO normally sends devices to the AG's digital forensic unit with SD cards still installed. Detective McCain himself stated he was taught not to remove the SD card to avoid data loss. Removing the SD card from Fosler's dash cam contradicted both his training and the LCSO practice. Well, he says he took it out and put it back in, so I don't know if that one's going anywhere, but okay. 6, failure to preserve camera settings. The dash cam's internal battery was allowed to drain, resetting the date, time, and wiping critical settings. Policy 16-1 requires preservation of original condition. that actually might have something here. Could they have told from that information what was recorded? I don't know. Failure to stop or lock the recording at the scene. LCSO's personnel, including Detective McCain, allowed the dash cam to continue recording after arriving at the scene. They could have either stopped the recording or used the lock button to preserve existing files. They did neither. Now, those actually might matter if the judge believes the prosecution's theory, this detective's theory, or what his assertion is, that, oh, we only saw front footing and front
Facing.
facing. And I do remember reading something where he says he thinks it got written
Overridden.
over, so it wouldn't have gotten written over. It's the same way you're supposed to put a cell phone in airplane mode as soon as you get your hands in it, or stick it in a fairway
As
bag.
far as 5 goes, though, I mean, they're saying so not to remove, it's bolded, not to remove the SD card to avoid data loss. So can you lose data from just removing the card?
I think it's probably possible that, how they say, like, even turning the phone on causes you to
Yeah.
lose some kind of setting, but,
Mhm.
I don't know.
I
These
don't know.
failures establish spoliation beyond mere negligence, unlike in Lee and Autry, where law enforcement followed standard practices. Here, officers acted contrary to policy, conduct that supports a finding of bad faith. And that's what I was looking for. I said I didn't really have time to read that case, but that if the thing just got deleted in the normal course of their, like we delete after X number of days, and they just, didn't preserve it, that's different. Conclusion. As the motion, the state's response, this reply, and the accompanying affidavit show, this case presents factual contradictions and technical impossibilities that require resolution at an evidentiary hearing. Because the court must make credibility findings regarding Detective McCain and other witnesses, these issues cannot be decided on written submissions alone. Spencer therefore renews his request for an evidentiary hearing to further develop the evidentiary basis for spoliation sanctions.
All right. So I don't have the affidavit here. I'm looking at
Let
the
me
bottom
check
of the doc.
let me just check the motion itself. Hold on.
Check your shit.
Um,
Mhm. So we did this one. Did this one. We did this one. And we did this one.
brief and support of defendant's motion to exclude evidence. No. No, maybe this one. Here we go.
Anything?
I'm checking it. Might be.
Anything?
No.
Damn it. What?
Nope.
Me no likey. I wanted to see that affidavit to see what Lachey or whatever the fuck his name is. Whatever the guy's name is.
Yeah.
I don't know. All right. Well, that's disappointing. I wanted to hear what their guy was going to say. All the shit.
Yeah.
Everything that guy just said is bullshit. Okay. All right. Disappointing. This is how we do it. All right. What's next?
I think those are the only ones that have like the state and so you can just pick something.
All right. So let's see. This is brief in support of defendant's motion to exclude evidence, or in the alternative, to order production of information forthwith. So this is defendant's filing. They're coming through Aaron and Michael here, and they are ordering they want a production order of information forthwith. State delivered 2 new sets of discovery on the eve of November 24th, 2025, motions deadline. 1, a report of data recovered from the black box in Fosler's truck, along with an accompanying analysis. And 2, AT&T records from Spencer's account and an expert report on cell tower location data relying on those very records, as well as additional data that has never been disclosed. Trust me, bro. You don't need to see those records, bro. I saw them. And you know what? I have a badge. Trust me, bro. We're good. Okay, the documents show
Wow.
that LCSO requested the black box extraction on June 6th of 2025. The Arkansas Staties pulled the data on June 10th, 2025, and Trooper Dooley completed his report on July 4th of 2025, more than 4 months prior to its disclosure. They also show that the state obtained a warrant for Spencer's AT&T data on October 22nd, 2025, more than a year after the event at issue. And the extracted files were saved on November 5th, 2025. Yet, none of this information was disclosed until November 20th, 2025.
As you go to that footnote, so that resolves my question of, well, if they're trying to claim that it gives some sort of precise location, they needed a warrant for his historic data. It sounds like they had one.
Okay, so the state produced more discovery on November 12th, 21st, 2025, and November 24th, 2025, to include the curriculum vitae of its experts. Oh, well, thank you. Thank you for those. The state also disclosed only in its December 3rd filings, just a week prior, it sought yet another warrant for additional AT&T and Life 360 records, and that its expert cannot complete another report without this new material. Evidently, the state is collecting evidence more than a year after the incident and less than 2 months before trial. The state attempts to justify its late disclosures by arguing that it need not to disclose facts or data supporting an expert opinion prior to a hearing. This is incorrect, sir. The materials at issue are independently discoverable regardless of their use in an expert's analysis, and the state's delay in obtaining and producing them is prejudicial. Both the black box data and the AT&T records are materials subject to disclosure as documents the state intends to use at trial. Documents belonging to the defendant and material obtained from specific searches and seizures. The black box report is also a report of a test or examination. See Arkansas Rules of Criminal Procedure 17.1. A45C. I'm guessing that's I. In addition, these materials corroborate Spencer's account and are therefore exculpatory.
And that was C1, by the way.
C1, thank you, baby. Thank you. Discovery rules in criminal cases, quote, promote fairness by allowing both sides the opportunity to full pretrial preparation, preventing surprise at trial. No one wants a trial by ambush. And avoiding unnecessary delays during the trial itself. That comes from 91 case, Mitchell v. State. When the state violates these obligations, exclusion is an appropriate sanction. Also, upholding exclusion of a late disclosed witness, and same. Hardaway v. State. Late disclosure of witness, same. Okay, so here the state waited until 1 business day before the motion's deadline to disclose the black box data, the AT&T data, and its expert analyses. Its first notice to the defense of any of this evidence, its first notice to the defense of to any of this evidence even existed. Even now, the state has not produced all the data underlying its initial cell tower report, despite its experts' reliance on it. Spencer objected to the admission of the expert testimony on the cell tower data on November 24th, 2025, on both substantive grounds and because of this incomplete disclosure. More than 2 weeks later, the data remains undisclosed, preventing defense experts from fully reviewing the expert's analysis or completing their own opinions. Introducing a second expert opinion based on the records the state only recently requested will again require expert review, again resulting in prejudice, and again be attributable solely to the state's failure to timely investigate. Truth there. with a pretrial. Man, you ever heard of that fucking Life 360, man? Fucking like the whole family's on that shit, man.
Yeah, we should have
Shooting
used that since the
investors.
historic cell site data can't really tell you where anybody is at any
I mean,
given
it
time.
fucking shows how fast the guy was driving, man. I saw my daughter doing fucking 90 on the good old 236 like 2 weeks ago. It's like, boom, there it is. We should do that. We should get that shit. Uh, with a pretrial hearing in 1 week, the holidays immediately following, and trial shortly after, the defense does not have sufficient time to meaningfully. Yeah, and there's no continuances of this trial.
She said that?
What she put in her last one. This is a final
Well,
continuance.
well, she either has to exclude it or give it a continuance.
I mean,
Unless the defense is
you
asserting
know who doesn't want a continuance?
right.
Aaron Spencer. He doesn't want a fucking continuance. I want this thing to go to trial. The defense does not have sufficient time to meaningfully review or make use of the belated disclosures or review and evaluate the forthcoming expert report based on data yet to be obtained or disclosed. The defense experts are already reviewing extensive late produced material and the persistent trickle of new evidence. The persistent trickle of new evidence and evolving expert theories continues to prejudice Spencer's ability to prepare for trial. These delays and the state's strategic timing have real consequences because the state did not timely obtain or disclose the black box and AT&T records, the underlying cell tower data, and the resulting expert opinions. The court should exclude any expert testimony regarding Spencer's purported location, as well as any future expert opinion regarding Fosler's purported location. The state's conduct has made preparing for and ensuring a fair trial impossible. If the court does not exclude the testimony, it should order immediate disclosure of all the data the state expert relied on or relied upon to form their opinions. Both Rules of Evidence 705 and 17.4 give the court broad authority to order production of data underlying expert opinions when that information is material to the defense. Here, the defense cannot meaningfully consult its own experts without it. Moreover, the defense experts must be able to review the data to form opinions. Yeah, you think? To assess the reliability of the state's experts. Yeah, you think? And to assist counsel in determining whether additional relief is warranted. All those.
They should have said something like, although the defense maintains that this is an inadequate remedy, it's better than nothing.
Yeah.
Because as soon as you propose an alternative, it's like, oh, well,
I'll just do that.
you said the alternative was fine. And right, the judge said, the trial court says what you said. And then the appellate court's like, well, you proposed an alternative. So seemingly that was
your idea. Ironically, the state continues to complain about delayed expert disclosures by the defense. What? Yet the defense disclosed its experts long before the state made any disclosure at all, and disclosed the additional potential rebuttal experts immediately after receiving its first notice on November 20th through the 21st of 2025. That the black box and cell tower data even existed. The state has also complained that it lacks information regarding the quote substance of the facts and opinions, end quote, or quote a summary of the general grounds for each opinion of the defense experts. Yet the state simultaneously argues that it need not disclose the phone records and cell tower data on which its own expert relies. Data that any defense expert would necessarily need to evaluate or rebut those opinions. The state has therefore manufactured the problem it now attributes to the defense, and it continues to compound by seeking new evidence and new expert theories more than a year after charging Spencer. This is the time to prepare for trial, not to launch new avenues of investigations. So, under the due process clause of the 5th and 14th, and Article 2, Section 8 of the Arkansas state constitution, Spencer has the right to present a defense. The withheld information is necessary to do so. Failure to compel its disclosure will violate Spencer's constitutional rights, including his right to a fair trial and to present and complete a defense. Wherefore, Spencer asks the court to grant the defendant's motion, exclude the challenged data and opinion, or, in the alternative, order immediate production of all underlying data and materials and grant any other relief the court finds appropriate. I mean,
Is there any sort of affidavit or anything attached?
no, ma'am.
Just check that there is some sort of state motion about evidence and renewed discovery. So maybe just in case, read that one. Like the second one there is renewed motion for discovery. Oh, bye, Bob. He's gone.
Wow, I had a violent sneeze there. It was a three-parter, bro. Nobody needed to see that. All right. I just got to the camera and mic just in the nick of time. Would have been explosive. People would have been horrified. All right. So what were you saying? I was wholly focused on my sneeze, my impending sneeze.
Which motion was that you just read?
So let me see. Okay, it was this one. Okay, so I'm gonna check it off.
But what was the date? Oh, the 10th.
10th.
Brief in support of defendants. So I don't know that these other ones have to deal with that. Like that second one is for discovery. So I think it's something different. So go ahead.
Yeah, I mean, this is a shorty, I think.
Yep, they're all short.
Yeah, this is just so this was filed back on December 3rd. State's brief in support of its response to defendant's renewed motion for discovery. Okay, intro. State has complied and will continue to comply with Arkansas Rules of Criminal Procedure 17.1 and will provide to the defense all exculpatory evidence in its possession, which is none, because your fucking guy did it, buddy. We're good. We're good. It will also provide any oral or written statements attributed to the defendant.
But we're not giving you our notes.
Yeah, no notes. You don't need any notes. Look, I have a badge. Trust me, bro. However, there is no requirement in Rule 17.1. That requires the state to provide the defense with a copy of its notes taken during witness interviews. So argument, Rule 17.1 states, subject to the provisions of Rules 17.5 and 19.4, the prosecuting attorney shall disclose to the defense counsel upon timely request the following material and information, which is or may come within the possession, control, or knowledge of the prosecuting attorney. 1, the names, addresses of persons whom the prosecuting attorney intends to call as witnesses at any hearing or at trial, and 2, any written or recorded statements and the substance of any oral statements.
And the substance.
Yes. Made
So
by
that
the
could be,
defendant or a co-defendant.
that could incorporate notes, but maybe there's some law that says no notes. In Illinois, we have a special rule. If it's a murder case, you got to turn over your notes.
No soup for you. 3, those portions of grand jury minutes containing testimony of the defendant. 4, any reports or statements of experts made in connection with the particular case, including results of physical or mental examinations, scientific tests, experiments, or comparisons. 5, any papers, books, papers, documents, photographs, or tangible objects which the prosecuting attorney intends to use in any hearing or at trial, or which were obtained from or belong to the defendant.
Which was kind of ties into the defense's last motion.
Yep. And then 6, any record of prior criminal convictions of persons whom the prosecuting attorney intends to call as witnesses at any hearing or trial if the prosecuting attorney has such information. Wow. You can't get the background on your witnesses? Really?
Yeah. I didn't do any background because I don't want to tell it to you.
How do we do that? B, the prosecuting attorney shall, upon timely request, inform defense counsel of 1, the substance of any relevant grand jury testimony. 2, whether in connection with the particular case there has been any electronic surveillance of the defendant's premises or of conversations to which he was a party. 3, the relationship to the prosecuting authority of persons whom the prosecuting attorney intends to call as witnesses. C, prosecuting attorney hi. The prosecuting attorney shall, upon timely request, disclose and permit inspection, testing, copying, and photocopying of any relevant material regarding 1, any specific searches and seizures,
Which
and
would go to
2,
the damn black box that they just talked about.
yeah, that damn black box, and 2, the acquisition of specified statements from the defendant. And then D, subject to the provisions of Rule 19.4, the prosecuting attorney shall promptly, upon discovering the matter, disclose to the defense counsel any material or information within his knowledge, possession, or control which tends to negate the guilt of the defendant as to the offense charged or would tend to reduce the punishment therefore. State has complied. We complied. And we'll continue. We're going to continue to comply with Rule 17.1A2, which requires all statements by the defendant to be provided to the defense. However, there is no such rule in 17.1 that obligates the state to provide a copy of its notes taken during a witness interview. Convenient.
Well, it depends if it contains the substance of their statement.
Yep. All right, there you go. That was good old Boopy Booper. I think that was that one, right? Let me double check. I already forget. Yeah.
Yeah, that's it.
That's the Boopy Booper. Okay, Boopy Boopers. Okay. State's brief is brief. So the state's brief
did that one.
I did.
You just read that one. Yeah, spoliation. I might have put it in there twice. There was a 12.4 and a 12.3 version. I think you read the 12.3 version.
Yeah. Well, it was 12.04 and then just 12.4. So you did put them in twice. Good on you, babe. Better to be thorough than
That's the way it was sent to me.
Okay. This was filed on the 3rd. This is the supplemental brief accompanying the reply in support of defendant's motion in limine to exclude.
Okay, so just
yes.
Wasn't just make sure go back to your list.
Oh, you're reading this one. It's a long one.
I knew I remembered seeing a longer one. Go back to your list. What's number 1? Go up. The first one
is state's second amended motion regarding the expert testimony.
Okay, I thought the state had.
This is them trying to keep all the defendants.
Right, but I thought they had a response to this because this is the defense's reply, but maybe we already read it.
Well, we read.
No, I meant last live on it.
Yeah, I don't know that we.
Not this. The response to which you were just pulled up that long reply.
Yeah.
All right, go ahead. I'll read it.
The big one.
How long is it?
473 pages. Jennifer Steele, licensed clinical psychologist. Dr. J Consulting.
All right, come on, just get
basketball hoopster. Oh, sorry.
Right, you might as well read this one then, if that's what.
Well, oh no, man. What? All right. All right. Okay. I'll read this one. You can read that really long one. They love you. Okay. The state's second amended motion in limine to exclude the evidence of the expert testimony comes now the state of Arkansas through their prosecuting attorney, the dude from Lone Oak. Okay, so they are moving this court for a pretrial hearing to determine the admissibility and relevance of now 5 expert witnesses disclosed by Spencer, and in support thereof states that Spencer's defense counsel served the state with notice of intent to call now 5 expert witnesses at trial and provided the CVs of said witnesses. See all 5 collectively as Exhibit A. The defense disclosure did not include the subject matter on which each expert is expected to testify, the substance of the facts, and the opinions to which each expert is expected to testify, or a summary.
It sounds like in part because the defense is waiting for more material from the state to know what their experts have to combat.
Yeah,
counter.
Not these ones. These are the ones. Remember we had our little debate about like the child psychologist.
Oh.
Yeah.
Yeah.
So in the absence of these disclosures, the state is unable to evaluate, and this court is unable to determine whether the proposed testimony is relevant under 401 and 402, possesses probative value that is not substantially outweighed by the dangers of undue delay, wasting time, or needlessly presenting cumulative evidence under Rule 403, or satisfies the reliability and methodological requirements of Rules 702 through 705, or is otherwise admissible. And then 4, a pretrial evidentiary hearing is therefore necessary to prevent surprise, undue delay, and the potential introduction of irrelevant, unreliable, and otherwise inadmissible expert evidence at trial. So we'll just look. So there's Jennifer Steele is a licensed clinical psychologist.
Wait, that's the next one, isn't it?
I think this is all her just work.
Okay.
I think. Let me see. I don't know. Like there was no
Wait,
other
stop
name here.
right after the A. Go. Go.
That this is her
Keep going.
Oh my god, that's her employment experience.
Right, I got it.
Okay.
Okay. I didn't know if it took a different, if it changed.
Did you guys see that? See how Allie was like treating me like that? Go.
Right.
I didn't see another name, bro.
Gotcha. You're right.
Thank you. Okay. All right. Wow. Long CV.
Yeah. I thought the font changed. It just like it looked weird. But it didn't.
I understand.
All right,
Okay,
here we
there
go.
you go. And then Carrie Landau,
Retired.
special agent, FBI. So Will County's Will County Child CAC Center. Is that Will us? Oh yeah.
Yeah.
Crest Hill, Chicago gal. All right. All right. So yeah, she's she would be testifying as to excuse me, the impact of sexual abuse and things of that nature, and trafficking and grooming and all that good shit, which I think is very important. You can see all the things that she has taught, seminars, a lot of trafficking stuff.
Yep.
Okay.
Keep going.
Yes, ma'am.
I'm like looking at time.
Clint Norris.
What the hell is Athleta and what does it say?
Las Cruces, New Mexico. So he currently works for the New Mexico State Police.
All right,
He's
so
an agent.
he's a cop.
He's a capper. He's a capper. Sexually related crimes / abuse, SA, violent crimes. Okay, so
I mean, the defense needs to say
he's a reconstruction guy.
okay.
Okay. Okay, and then Brandon Purchase. He's a
Cybersecurity and digital forensic expert. All right.
All right.
Is that 5 or there's one more?
All right. Breathe easy. That's only 4.
Okay, there's your
Lawrence Montanez, CV. Let's see, what does he do?
he must deal with that thingamajig.
He looks like another reconstruction guy. Collision Safety Institute, welding. He's an arc welder. iCar welding. Mercedes. Yeah, I think he's another accident.
No, I mean, wait. Scroll up. Right there. Stop.
Wait, where? Did I
Go
do it
down.
right?
No, go down. Down. You're going up. Right there.
Okay.
Yeah, New York Department of Insurance, Delaware Department of Insurance. What he seems to be an insurance adjuster.
You're
I don't
an
know.
insurance adjuster.
At least at some point he was.
I mean, okay.
Something to do with accident reconstruction. You're right. I guess.
Collision Hub. Okay, so I think that's the 5th and final.
But the prosecution shouldn't have to guess.
Yeah, he's a collision guy. Oh yeah. The truth about nuts and bolts. Okay.
Well, him and Jeff Lang, they do a lot of work together.
Yeah, those guys write a lot of shit together. Busy boys. Busy boys. All right, so that's that. Okay, you're up. Ay. Ay. Let me make sure I don't accidentally
No,
do the
no,
short
if it's no, this one. I'm the one reading this one. I'm reading this one.
one. What?
I'll take this one.
Okay.
Supplemental reply in
Wow.
support of defendant's
Y'all
motion
see
in
that move?
limine
She just pulled that some
to
bullshit.
to exclude evidence. The defendant, Aaron Spencer, buying through his attorneys, Aaron Casanelli, and somebody, because I can't see it,
Michael Kaiser.
submits this reply in support of its motion in limine to
Hoodie. Oh, sorry.
I didn't even read it yet, to exclude evidence along with the accompanying supplemental brief in support. Aren't
Footy.
we reading this? Aren't we reading the brief? What's happening? All right.
Okay.
Pursuant to the court's November 17th, 2025 order on briefing, Spencer refiled. Okay. So we've gone over this. Like he had to refile stuff. So we've probably read this before, but it's short. So we'll just keep going. Like that he's refiling certain things along with a brief. But this does say at the top brief, right?
Yeah.
Okay.
Briefing. Oh,
No.
reply. Oh, you included a reply. Oopsies.
Go back and see if that's what the other brief is about.
Oh,
But is this the same topic that of the one we just had up?
come on, dude.
That's
Don't
what
you
I'm
remember?
supplemental brief and lemonade to
Exclude evidence.
and the others to
You didn't
exclude
get it.
experts.
You did, yeah. Reasonable belief. Oh yeah. Just read it.
Okay. Spencer is charged with second-degree murder. You got to make a. I'll do it. I blew it up too much. Sorry. And has asserted two statutory justification defense under 5-2-607 and 5-2-604. Once justification is asserted, is raised, the state must disprove it beyond a reasonable doubt, and the standard is objective. What an ordinary, prudent person would have believed under the circumstances. We went over this ad nauseum, I think, on the last live. It's not about what happened or what didn't happen. It's not about how she got out of the house or how she didn't get out of the house. It is about what was Aaron believed and if it was reasonable to believe under the facts that she was taken by force, that she was taken in her sleep, that she was, abducted, whatever. The state
That
must,
was the whole thing where I'm like, the clock starts as soon as he lays eyes on his daughter in Fosler's truck. That's when the fucking clock starts. Nothing
or when
happened
he sees
beforehand.
she's not in her bed and the dog was barking.
I don't like that one. I don't like that clock.
All right, whatever. The
That
state
clock
must
goes back too
disprove it
far.
beyond a
Because he doesn't
reasonable.
know for certain he's with her. I'm sure he suspects it, but
The
he
state
only
must
knows what he knows.
Right. I agree with you. When he saw Fosler in the car, referring back to what he knew about how the kid was gone and the dog was barking. All right. The state must disprove it beyond a reasonable doubt, and the standard is objective. What an ordinary, prudent person would have believed under the circumstances. The state's claim that a stray.
Expletive.
I know, but okay. The state's claim that a stray expletive in July, shows Spencer lacked a reasonable belief on October 8th is legally impossible. Under Child v. State, justification requires acquittal if a reasonable person would have believed imminent harm existed, even if the defendant himself harbored some culpable mental state. Now, we talked about this before. Like somebody harasses, stalks, kills one of your family members, and you are like, I want to kill this motherfucker. If I find this motherfucker, I'm going to kill him. If I see this motherfucker again, I'm going to kill him. And then that motherfucker comes back to your house and tries to murder you and your wife and your kids, whatever, chasing you around the house. I was saying this like horror movie style. You still have the right. It is still justifiable if you kill that motherfucker.
That motherfucker did.
So a month's old expression of frustration sheds no light on what a reasonable person would believe when confronted with Fosler's conduct on October 8th, whether the jury views it as forcible kidnapping or continued grooming. Either scenario created legal justification and certainly reasonable cause for Spencer to act to protect his teenage daughter from a sexual predator who refused to leave her alone. Yes, I'm going to say it again, babe, for the people in the back. either scenario created legal justification and certainly reasonable cause for Spencer to act to protect his teenage daughter from a sexual predator who refused to leave her alone. The state's reliance on Dimas Martinez is misplaced. That case involved .380 ammunition and .380 firearm directly tied to the murder weapon and relevant solely to access. It had nothing to do with motive, ideology, planning, or intent. There is no comparable evidentiary link here. Spencer's July remarks were hypothetical reaction to a hypothetical scenario and bear no temporal, factual, or logical connection to the events of October 8th. Now, again, you guys, this is a supplement, or a essentially a reply to what the state had said before. And we talked about that. It was like this case that they cited, the state, that dealt with like a firearm, and whether a guy had access to the firearm is like completely different than what they were talking about here. So this, you got to go back and watch the last live if you forget some of that, but we went over that there as well. The state intends to frame the July remarks as evidence of vigilante ideology, a tactic courts have recognized as an improper emotional appeal. The inflammatory danger of such rhetoric far outweighs any minimal probative value the state claims to extract from a single offhand expletive. Rule 403 squarely prohibits its admission. And I will say it again. This is precisely what 404 and 403 are intended to keep out. Under 404, the whole point is you can't say, well, at some point he wanted to do vigilante justice. So now you have to believe at this point he did vigilante justice. It is literally saying that he has this characteristic of vigilante justice. It's precisely what the law is meant to exclude. So returning to the body here, Rule 404 bars it as well. Here we go. The state concedes it seeks to introduce character evidence to show Spencer acted in conformity with a purported trait of vigilantism. Exactly. Spencer has not placed his character at issue, and Rule 404B does not permit admission of prior statements to prove conduct in conformity with a character trait. Nor does the state identify any permissible Rule 404B purpose that a midsummer expression could possibly satisfy. Nothing about the July conversation resembles the charged conduct as 403 requires, even for 404B evidence that Christmas things blocking there's nothing there. For these reasons, the July statements are irrelevant, inadmissible, and overwhelmingly prejudicial. The court should exclude them and prohibit the state from advancing arguments premised on vigilante characterizations or other improper references to the July conversation. Wherefore, the defendant, Aaron Spencer, asked the court to grant the defendant's motion in limine and for other relief this court finds appropriate. All you, baby. For the big guy.
Egregious, preposterous.
Exactly. I love how I switched it up and made Bob have to read the long one. Makes me happy. No, that's the one I just read. You're muted, right, babe?
Yeah, I've been keeping my cough button on. That's a low-key important motion because that is the whole fucking, that's the entire state's theory. Right. They want to be able to say, oh, you know what? Fucking Aaron Spencer said back then he wanted to kill him. He could take the law into his own hands.
And they're trying to use it under the guise of motive, that shows motive.
He did exactly what he wanted to do all along. Like that's going to be their whole thing. And they're like, and it's bullshit. It's ridiculous. They can't make that the basis of their entire case on some bullshit. That's where I'm at with it. All right. Supplemental brief. This again was filed on the 3rd of December. Boop. All right. Can you all see that? All right, so this is a brief accompanying the reply in support of the defendant's motion to eliminate to exclude evidence. Okay, so here you go. So the state builds entire case theory on one frustrated mid-conversation utterance. Bullshit. From a single expletive, the state extrapolates motive, intent, plan, and personal ideology, projects a future mental state, nullifies Fosler's behavior, and attempts to extinguish the justification defenses. It is a remarkable house of cards built on a foundation of bullshit. Ooh, well played. Well
Like what you
played.
did there.
All right. Now,
The
let's see.
footnote is just again saying how they're refiling this with that brief.
Excellent.
So I could have skipped the last one because this is the brief that
Yeah.
accompanies
Yeah.
that.
Wow. So Spencer has already exposed the state's factually distorted account in his November 24th, 2025 briefing. Rather than correct course, the state repeats the same narrative verbatim in its new response and simply layers on new arguments about relevance, probative value, and admissibility, none of which withstand scrutiny. So, the relevant law, Spencer is charged with the second-degree murder of Michael Fosler, pursuant to Arkansas Code, which requires proof that he knowingly caused Fosler's death under circumstances manifesting extreme indifference to the value of human life. Spencer has asserted two statutory justification defenses to this charge. First, Spencer asserts deadly force justification under 5-2-607 in defense of his daughter and himself. The statute provides that a person is justified in using deadly physical force if he reasonably believes that the other person is, one, committing or about to commit a felony involving physical force or violence, two, using or about to use unlawful deadly physical force, or three, imminently endangering the person's life or imminently about to victimize the person from the continuation of a pattern of domestic abuse. And Allison, I hate three. I don't know. Like, does this fall under that?
Right. And we hope that the law, as interpreting that pattern of domestic abuse, would apply to. I mean,
Well,
look,
they better tread carefully because they were trying to make it seem like, oh, they were having a relationship.
exactly. Either way you look at it, I've seen them consider RAPE as a prior sexual relationship when they want to exclude the sexual history of a victim. And I'm like, wait a minute. The whole point of excluding the sexual history of a victim is so that you can't use it to say she's promiscuous, she's this, she's that. So don't, so she wanted it.
Yeah,
When you're
the R shield.
right, when you're assaulted, you did not make a decision. It is not about your decisions about
consent.
or your promiscuity. It's about what somebody did to you. So they use it there. So here, a domestic relationship is a former sexual relationship. Under the law, this could be a former sexual relationship, which would put it right into a pattern of domestic abuse. So but I am assuming that Arkansas law has defined domestic abuse widely enough to encompass this, but we shall see.
Oh, really?
Maybe they
Remember the kidnapping statute? I would have zero faith in anything that they're doing is not archaic. Spencer has also asserted a choice of evils defense pursuant to Arkansas Code annotated 5-2-604.
I thought that he filed a motion saying he took that back because the law was clear that you can't have a choice of evils defense if you assert self-defense or defense of others. And I thought
I can't remember if they did. Like,
I thought they did.
It felt like they didn't withdraw that. It felt like, I don't know what they definitely filed something withdrawing something.
Right.
I don't think it was this choice of evils. Like, I don't.
Right.
I remember being somewhat confused by it. So,
and again, that could apply to the hitting of the car, I guess. But go ahead.
Maybe conduct that would otherwise constitute an offense is justifiable when one, the conduct is necessary as an emergency measure to avoid an imminent public or private injury, and this is not an or situation; it's an and according to ordinary standards of reasonableness, the desirability and urgency of avoiding the imminent public or private injury outweigh the injury sought to be prevented by the law prescribing the conduct. So reasonably believes or reasonable belief is defined in Arkansas Code, Section 5-1-102, as a belief that one, an ordinary and prudent person would form under the circumstances in question, and two, not recklessly or negligently informed.
I'd love to see the same thing written for domestic abuse.
Yeah, 100%. So to convict, the state must prove beyond a reasonable doubt that Spencer knowingly caused Fosler's death by deliberately creating a risk that was practically certain to result in Fosler's death. See Turner v. State, 2019 case. The state must also prove beyond a reasonable doubt that Spencer did not act under a reasonable belief that Fosler was committing or about to commit a felony involving force or violence, or using or about to use unlawful deadly physical force against Spencer and or his child. And that Spencer's conduct was not necessary as an emergency measure to avoid an imminent harm, and that the desirability and urgency of avoiding that harm did not outweigh the injury prescribed by the murder statute. All justification defenses must be submitted to the jury if any evidence supports them. And the jury must be, are you waiting to say something?
No.
Oh, and the jury must be instructed that the any reasonable doubt of any of them requires acquittal. So 5-1-111C, thus, once raised, the state must disprove these defenses beyond a reasonable doubt. 2018. By statute, a justification such as self-defense is considered an element of the offense, and once raised, it must be disproved by the prosecution by beyond a reasonable doubt. So here's the argument: one, an expletive is not relevant evidence. The state argued that a frustrated bullshit Spencer uttered in July of 2024 somehow reflects his extrajudicial mindset months later on October 8th of 2024. The state's response at 4, the state claims that this remark shows that, quote, he, A, acted with the prohibited mental state on October 8th, and B, he did not act with reasonable belief required for justification, end quote.
Exactly what 404 prevents. You can't say he did it because, look, he thought this way before, so he thought this way now.
Right. But this testimony would not assist the jury in determining what an ordinary prudent person would think is reasonable under the justification statute. If the jury finds the defendant reasonably believed he or his child faced imminent physical harm and the other statutory conditions are met, the justification statute requires acquittal, even if the defendant acted with a culpable mental state. So the state's proposal to use a single expletive to show that Spencer, quote, did not act with reasonable belief, end quote, risks confusing the jury because the statute applies an objective standard, not a retrospective psychoanalysis of the defendant's mood months earlier.
You know, and this is the type that of argument they always apply when you're talking about policeman's, reasonableness for a stop, reasonable, objectively reasonable belief that a crime might be committed or that they've got grounds for a Terry stop. And it specifically says it does not matter if the cop's really pulling someone over because they're black and they think black people commit more crimes if they had an objective reason to actually pull them over. Look, the guy didn't use his blinker. The fact that he really is only pulling him over because he's black doesn't matter because there was an objective reason to pull him over. It's the same analysis here. Doesn't matter. We like the one I just gave before, like, I'm going to kill that motherfucker. Doesn't matter that he wanted it, that someone may have wanted to kill someone. If they gave them legal reason to justify their killing right then and there, if they acted it justifiably, it doesn't matter what their subjective belief was. Like, I was just waiting for you to give me a reason. Give me a reason.
Right.
Come on.
Right.
Come on.
Right. Goading them. And the suggestion that one midsummer conversation dictated Spencer's mindset 3 months later stretches credulity past its breaking point. Spencer's mindset on October 8th, 2024 was shaped by the circumstances Fosler created that morning, not by an offhand remark in July. Whether the jury concludes Fosler forcibly kidnapped Spencer's 14-year-old daughter or groomed her so he could continue A-ing her, if not disappear her entirely, the analysis is the same. Either scenario created legal justification and certainly reasonable cause for Spencer to act to protect his child from a predator who refused to stay away from her. The state's position boils down to this. If Spencer thought his 14-year-old daughter might have gone willingly with her abuser, Arkansas law required him to stand aside and hope for the best. That is not the law. It is offensive to common sense, to the text of the justification statutes, and to the protective duties Arkansas law recognizes when a child is in danger. What Spencer said months before does not matter and is not relevant. What matters is what happened on the morning of October 8th of 2024, when Fosler, by his own choices, presented an imminent threat of harm to his victim, and when Spencer had every right and indeed every obligation to act to save his child. 2, inflammatory rhetoric has no probative value and is highly prejudicial. The state offers a novel argument that a single expletive can be sufficiently versatile to prove Spencer's motive, intent, and absence of justification in a crime committed months later, and that its, quote, overwhelming probative value far outweighs a negligible risk of unfair prejudice.
Please. Please.
State's reliance on Demas Martinez is puzzling.
Okay, yes, this is what we talked about before, and okay, I'm glad to get into it.
The case bears no resemblance to the situation here. In Demas Martinez, ammunition found in the defendant's vehicle a month before the murder was admissible because it matched the .380 ammunition used in the homicide. Likewise, the .380 firearm the defendant urged a third party to retrieve, though not conclusively proven to be the murder weapon, was admissible because it showed his access to a 380 caliber at the time of the crime. In other words, both pieces of evidence had clear, specific physical connections to the murder weapon and were independently relevant to prove the defendant's access to it. The state misrepresents Demas Martinez by claiming that the evidence there showed the defendant's preparation, planning, motive, or intent. It did not. It showed access to the gun and ammunition used in the murder. Nothing more. The evidentiary link is what justified admission. There
That is
is
absolutely
no
true. We
Yeah.
read it, we went over it on our last live. It was
Yeah.
absurd.
There is no comparable link here. Spencer's July statements have no connection, temporal, factual, or logical, to the charged conduct 3 months later. Those statements addressed a hypothetical situation. A pedo who, even after arrest, reoffends, and the right of a person to protect themselves and others from such an attack. Nothing in that conversation supports the conclusion that Spencer planned to kill Fosler months later, let alone the state's extraordinary suggestion that Spencer intended to allow Fosler to assault his child as a part of that supposed plan. Simply put, Demas Martinez involved evidence directly tied to the murder weapon. The state's attempt to equate that with a frustrated remark in a hypothetical discussion about protecting children is legally and factually untenable. Even more concerning, the state argues that the remark shows Spencer's explicit contempt for the prohibition on vigilante justice, extrajudicial mindset, personal code, philosophy of lawlessness, and his vigilante ideology. These terms meet the very definition of propensity, an inclination or natural tendency to behave in a certain way. This is exactly the type of information prohibited by 404. Evidence of a person's character or character trait cannot be admitted for the purpose of proving he acted in conformity with it on this particular occasion. Yes? Yes?
I'm coughing. Sorry.
Oh, moreover, courts have recognized that vigilante rhetoric is a classical appeal to passion that it risks inflaming a jury and constitutes prosecutorial misconduct, State v. Campos. The same danger arises here. The term carries an emotional charge, wildly disproportionate to any probative value the state claims to extract from a single frustrated expletive uttered months before the incident, allowing the state to frame the case around loaded character judgments rather than evidence would invite precisely the unfair prejudice rule 403 prohibits. For these reasons, the July statements are inadmissible under Rule 403 and Rule 404. The court should exclude the challenged evidence and prevent the state from advancing argument premised on an inflammatory vigilante rhetoric. 3, Rule 404B bars admission of the evidence. In its amended response, the state concedes that it seeks to introduce character evidence to show that Spencer acted in conformity with that character trait.
That's how I read it.
Yeah. Vigilantism, recognizing vigilantism as a character trait subject to Rule 404. The state argues that it was vigilante ideology that drove Spencer's actions. Such evidence is inadmissible under 404A1 unless the defendant first places his character at issue, which Spencer is not. It is likewise barred by Rule 404B, which prohibits using other acts or purported character traits to prove action in conformity with that character. So the state initially appears to recognize this bar, asserting the statement it seeks to introduce are not evidence of other crimes, wrongs, or acts under 404B, but merely expressions of belief. Yet in the next breath, the state insists that these same statements are admissible under various 404B exceptions. The state cannot have it both ways.
Exactly.
Having conceded the statements are not Rule 404B evidence, it cannot invoke Rule 404B's exceptions to justify their admission. And even if the court were to construe the statements as 404B evidence, the state never explains how a single frustrated utterance satisfies any of the exceptions it lists. Moreover, 404B evidence is only admissible if the prior act and the charged conduct bear sufficient similarity to satisfy Rule 403. The state does not attempt to explain how expressing an opinion, however colorfully phrased in a conversation with a third party, bears any meaningful resemblance to Spencer's defense of himself and his child against a violent predator. In short, the state's theory fails under Rule 404A, fails under 404B, and collapses under Rule 403. Conclusion: for all these reasons, the July statements are not relevant, not admissible, and not probative of anything the state claims that they prove. They do not illuminate Spencer's mental state on October 8th, 2024. They do not undercut the justification defenses, and they have no similarity to the charged conduct that would permit admission under Rule 404B. What they offer in prejudice dwarfs anything they could conceivably contribute in probative value. So accordingly, the court should exclude the challenged evidence in its entirety and prohibit the state from advancing arguments premised on inflammatory vigilante characterizations or other impermissible uses of the July conversation.
They surely should, but
So there
we
you
shall
go.
see.
All
All right.
We all caught up.
Yep.
We did it.
Pokemon has been a member for 23 months.
Love you,
Longtime
Pokemon.
fan member. Hit the like ski, please. Ah,
Love it.
thanks,
Love it.
Pokemon, and thanks for your continued support. OG.
Super OG.
Yeah. Dr. Jen Toxic, member for 10 months. Thanks for your continued support. Happy holidays, fam. Aaron for Sheriff. Love you. Yes, Aaron for Sheriff. If you are not following him on X, go ahead and do so.
Yes.
Thanks, History and Homicide. Always good for gifting Defense Diaries memberships. We appreciate that.
Thanks, you guys.
Rosie's Overruled, member for 7 months. Thanks for your continued support. Love all of you. Thanks, Allie and Bob, for doing this. Well, you're welcome.
Thank you.
Boris, thank you for your generosity. Thanks for covering this. And Boris gifted 5 Defense Diary memberships. Thank you.
All the family hugs.
Venice Blue Crash Batty.
Venus.
Oh, Venus Blue Crash Batty. Thanks for your generosity. I'm here for Allie turning into Samuel L. Jackson every day. Motherfucker. Yes, ma'am. This is why I show up. Hashtag Aaron Spencer. Hashtag Rogue Alley for the win. Hashtag Defense Diaries. Well,
Say
thank
what
you.
again?
Say what again?
What?
Oh, right. Yeah.
Yeah.
Give me a reason. Right. Classic Overthinker. Thanks for your generosity. Support for your coverage of Aaron and Rick. Of Aaron and Rick Allen.
Aw. Thank you.
Nev, member for 17 months. Thanks for your continued support. Sending prayers to fellow Aussies.
That's a wow.
Thanks, DD. Yes, I am also sending my prayers to the fellow Aussies. What
Thanks,
horrible,
Nay.
horrible
Not
situation. Oh, Nay, not a V. Sorry.
Yes.
And thanks for your continued support. And our thoughts are with you guys out there.
Indeed.
Nikki, have you ever seen the state withdraw from a case? I can't understand why they are moving forward with this. Sometimes what I have seen is they lose a huge motion and they dismiss without prejudice. They're, saying that they're going to reinvestigate and refile. I've seen them dismiss certain charges. Like we win in a motion and they like drop the higher charge and they amend the charge. But I think they know everything about this case. They know their case is shit for whatever reason they are pursuing it. And I can't imagine at this point them just walking away. But maybe if they lost that motion about using the bullshit and arguing vigilante off of that, maybe they would pull it. Maybe they would. I mean, someone needs to pull their head out of their ass.
Yeah.
Maybe it would give them a good reason. Like, we lost a really important motion. We really just don't have any evidence. Like maybe it'll give them the excuse to do what they should have done from the jump. You never know. So thanks, Nikki. Sarah Bahu. No, that doesn't sound right.
It seems.
Okay. Yeah, thanks for your generosity. And the best dramatic reading award goes to Bob. He always does. Best acting award goes to Allie. Thank you for covering this and your Buried podcast. Yes, Bob is amazing.
Thank you.
Amazing. Unburied.
Thank you. Thank you very much. Thank you. Thank you very much. All right. So, I think that gets us caught up. And as far as motions, they're done. The time for motions is over.
Sounds like there's a hearing coming up, right?
So I think that there does exist a slight risk that the trial gets continued if she
doesn't exclude their experts.
Well, not the experts. If she finds that, they don't have enough time once they produce that,
right?
The discovery, and they're like, well, this is voluminous. We don't have enough, the holidays are here. So, the hope would be that Aaron and Michael could get the discovery over to their experts and they can handle shit between, because the state's not going to be able to turn around and bitch about it. Like,
they're doing.
Oh, they're giving us no, I'm saying they turn the shit over. They hand it over to their experts. The holidays and their experts say, okay, well, we're going to prepare reports or not. But they review it.
Yes, sure.
And they're coming back, and the state can't turn around and whine and say, "Oh well, we're only getting it a week before trial. Tough shit. Should have turned it over in a timely fashion." That's what you get. You know what I mean? So, because Aaron Spencer does not want to wait for trial. The Spencer family does not want another continuance. I can tell you that definitively.
Right.
I'm not guessing on that. Like they want this thing to go to trial. It's time. No more delays. Let's go. So, I mean, it's going to be curious to see how she's going to handle that. So I don't know.
All right, everybody. It's getting late. We
all right.
love you.
Everybody, make sure you like, share, subscribe. Please, 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 please. That really helps us grow the channel. If you're a replay, of course, as always, just leave a comment. Start a conversation. Don't be afraid to have a conversation with people in the replay crew. They're same people that are here, except they weren't awake or not available. They're just watching it later. So get the combos over there. Tomorrow, we're going to be doing, I think we're going to be doing a primer for Alan. Because the 17th is Wednesday. And, you know, if it's like your typical appellate lawyer, I would not be at all surprised if that thing does not get filed until 12 or 11:59 p.m. Yep. So, you know, because it's going to be due. You got to get it in before the stroke of midnight.
And are we going to have one of the trial lawyers with us once that gets filed, when we go over that? Is that the plan?
Wait, what?
Is the plan to have one of the trial lawyers on with us once the appeal actually gets filed?
Yeah, I think Andy wants to come on, and Osbrook definitely wants to come on too, which I think are two very different viewpoints that I don't necessarily know. I want to have them both on.
I don't think together. It's
right.
Too many lawyers.
That was my
where
point.
I'd have to dip out.
It's not even that there's too many lawyers. I don't mind that. It's just there's, you know, you got one of the trial lawyers and you've got somebody who's been helpful in post-conviction stuff. They just have different viewpoints. Andy's not an appellate lawyer or a habeas guy. Osbrook is. They'll have different perspectives, and I think that each lawyer will bring different things to the table.
Well, maybe we can have Osbrook on when we do the primer and we go over the categories that they put out there.
I mean, Michael hit me up specifically, like he's definitely going to want to go through the brief with us. You know what I mean?
All right. Well, then maybe we can bifurcate, have them both.
All right. But the other thing that I want to do tomorrow, at the very least, is I want to conclude, and Allie, you don't have to even join me. I'd love if you did. I want to conclude the second day of the hearings for Zach Adams for his post-conviction. But I also want to go back. I don't know that I'm going to be able to do it tomorrow because we're planning on doing this thing later. Because I'm recording with Tony at 11. Come over to his YouTube channel. We'll be hanging live. We always do that live at 11 Central. But keep an eye out. I'm going to probably set that for like early afternoon to give us a little buffer for whatever we're going to do in terms of Allen primer. And so, yeah, that's the plan for tomorrow. And I know that Sarah Patrick has a hearing tomorrow. I really want Allie to look at that thing. I'm not getting the impression that it's going to be streamed in the morning. So if somebody knows differently, let me know. That's something I definitely want you to look at, babe. It's one that I think you're going to want to check out. Like, seriously. So, all right, y'all. We love you so very much. Make sure once again to shrink down the chat, hit that like button.
And for God's sakes, if you're not already subscribed, do it. It's free. It's free. We're almost at 60.
Free. It's so free. I got to start making videos. Like, videos are like, I have to. I mean, we'll still do lives, but I have to start making videos.
All right.
I've come to the conclusion. Tony does a shit ton of videos. He's up at like 94. He just but nobody's on his lives. He just does videos. He does lives. I'm telling you, videos are part of the mix here. So, all right, y'all, we love you so very much, because without you, I'm just an old man
sitting around talking to his wife.